The Supreme Court has upheld the most common method of administering lethal injections for executions. The justices today rejected a challenge to the procedure used in Kentucky, in which inmates are put to death by a series of 3 drugs. The decision has ramifications for a number of states. Correspondent Shannon Bream has that story.
Roughly 3,300 people sit on death row across the United States. Today, in upholding the constitutionality of lethal injection, the Supreme Court removed a legal roadblock to their executions. Since the court took up the case of 2 Kentucky double murderers who challenged the 3-drug cocktail, 19 states across the country put their executions on hold, waiting to see whether the court would find the method in violation of the 8th Amendment ban on cruel and unusual punishment.
By a 7-2 decision today, the U.S. Supreme Court removed one of the principal legal impediments to carrying out sentences that were justly entered by a jury of the defendant's peers and to providing final relief to the grieving families of the victims.
The parties to the case agreed that if administered properly, Kentucky's lethal injection method is humane. But the petitioners argued there is a chance the first drug used to render the inmate unconscious could fail, leaving the person aware but unable to cry out in pain as the final drugs designed to cause death are administered. In announcing the court's judgment, Chief Justice John Roberts wrote, quote, "An isolated mishap alone does not give rise to an 8th Amendment violation, precisely because such an event, while regrettable, does not suggest cruelty or that the procedure at issue gives rise to a substantial risk of serious harm." But in writing the dissent, Justice Ruth Bader Ginsburg said, quote, "Rare though errors may be, the consequences of a mistake about the condemned inmate's consciousness are horrendous and effectively undetectable after injection of the second drug." Kentucky has put numerous safety nets in place, including trained medical professionals with at least a year of experience and a warden and deputy warden to remain in the chamber with the inmate to detect any trouble. Critics say that's not nearly enough.
America is better than this. The Supreme Court is not, and only 2 of the 9 justices concluded that we should ask the courts to consider whether or not there aren't safer and better ways to do this.
Even Justice John Paul Stevens, as he wrote a concurrence in support of the opinion, seemed to question the very foundations and principles it was based on. Quote, "The time for a dispassionate, impartial comparison of the enormous costs that death penalty litigation imposes on society with the benefits that it produces has surely arrived." As for the states that put their executions on hold while awaiting this opinion, some are wasting no time. Before the day was over, Florida Attorney General Bill McCollum had already filed a motion to expedite the execution of a convicted rapist and murderer who had gotten a temporary reprieve. Many other states have signaled they are not far behind. Brett.
Shannon, thanks.